All right. We are now on the record on multiple cases. I'm going to read the case captions and then make sure that I know who's here. The first case I'm calling is 22 CB 8259 Kyle Rohrig, and that'd be you, sir.
Yes, Your Honor.
Okay, versus Megan Poss. Poss? Who is that?
Yes.
And is it Poss?
Boss, yeah.
Okay, so you're, okay, thank you. The next case is 22 CV 8260 Kyle Rohrig versus Steve Poss. That'd be you, okay. 22 CV 8261 Kyle Rohrig versus Megan Stark. Thank you, miss. 22 CV 8262 Kyle Rohrig versus Jeff James. Okay, and then 22 CV 8263 Kyle Rohrig versus Megan James. Is that you, miss?
That is me.
Okay. I think the recording system can pick you up, but for purposes of the record, we have you're sitting in the back right now to tend to your young daughter, correct?
Correct.
When it's your turn to testify, I may have you switch out with Mr. James's. Okay, it's making sure I'm matching the people up correctly, okay. Then I may have you switch out, because I want to make sure that your testimony is on the record. I also have before me case number 22 CB 8915, and that's Jeff James versus Kyle Rohrig. Mr. Rohrig, it's my understanding that you just received service of this case today.
Yes, Your Honor.
Okay. Are you ready to proceed? Because under the statute, you just found out today that you
Oh.
have this other case pending against you.
Your Honor, I was shocked that I didn't receive notice of it earlier. I was already waiting for it, so I was even shocked when I didn't receive one until now, Your Honor. So I've already been prepared. 'Cause
Okay.
all of it's conjoined together anyway, so it
So
doesn't.
that's my question to you. Are you okay with consolidating Mr. James' case against you and having it heard today?
Yes, Your Honor.
So you don't have to come back?
Yes,
But it's your decision
Yes, Your
because you're
I'm-
entitled to 48 hours notice.
I'm wholeheartedly ready to go. Like I said, I prepared for it already. Like I said, I was surprised when I got it here in the courtroom today, obviously, but I wasn't shocked that one was going to be filed against me.
Okay, well, with that, and when you filed this, you knew there was a possibility that you'd need to be prepared to go forward today? So you're ready? Okay, all right. Okay, thank you. Okay. Trying to do this orderly. Before we start with presentation of testimony or evidence, Mr. Rourke, do you have any preliminary issues to raise?
Yes, actually, I do. In the two that were filed against me by Megan James and Jeff James, as they committed perjury because they can't admit to being part of the group of the Columbus Inline Dance Collective because it proves tampering with evidence from all cases from 2018, both in the, what all were they? Were small claims of Franklin County, Franklin County Common Pleas, the frivolous lawsuits that they said I had, which that was new evidence. On top of that, all my criminal cases, and now also this CPO and a civil case that I have against Columbus and Inline Dance Collective with Flanagan's Double currently in Judge O'Donnell's courtroom. I'm sure you know of her upstairs. And not only am I raising that preliminary issue now, but I also have proof that they withheld, stating that their ORC, unauthorized practice of law lawyer, Mr. Paz, not only got on my TikTok, but liked the video to try to incite me to violence to go after him, just like he did in Florida, when he knows, as per the Florida ruling in 21 CM 5782 TAC Alpha, State of Florida v. Rohrig, I won that as a defendant pro se litigator. That the judge even said that he came near me and then played the victim. Not allowed to do that. He's doing that here today. And Megan James and Jeff James both knew that prior to coming into this courtroom because they're good friends, and he's a VIP member of not only Flanagan's Dublin, but Columbus Inline Dance Collective, which is also operating as an illegal business in the state of Ohio.
Okay, all right. So I understand you're raising certain issues, legal issues, but a lot of what you're raising has to do with what testimony evidence they may be presenting or things that they have said
Well,
in
I'm
other
already-
pleadings,
Well,
right?
I understand what you're saying, Your Honor, but I'm going to be objecting to any of them taking a stand under Ohio Evidence Rule 616, 613, and 608, and under State of Ohio v. Johnson. Because they impeach themselves under self-contradiction. They have a financial and personal gain. They also have personal issues themselves that they are trying to hide, which causes them to be impeached, as well as they've already admitted to the CPOs against me being illegal, with Ms. Stark admitting to being swiping right on me on Tinder. Because she claimed, and I quote, "I'm scared that he's going to come into my," her daycare or whatever she worked at the time, or still does, I don't know, that I was going to use my military gun training, which I have none, and I proved that. On top of that, that I was going to go into that daycare and shoot her and those kids up.
Okay.
And then not even a month later, it turns
All
out
right,
it's
I understand what you're saying,
All right.
but preliminarily, I I can't just go based on things you're saying and say, you know what, I'm not gonna let any of you testify today, okay? I'm gonna have to let them testify, and then you can object to their testimony and raise issues if you think
Oh,
it's inadmissible,
I-
okay? But I appreciate the fact you're giving everybody a heads up that that's what's gonna happen, right?
Sure.
Thank you, okay. I'll just go in order.
Yeah, well,
Mr. Pass,
yeah, well, okay, yeah,
do you have a,
Yeah, I have several motions that we can, wanna put them up here? We have copies.
do you have
I'm, I'm objecting because I never received a copy and he had more than 2 weeks to serve me. That's inadmissible, Your Honor. I haven't even
well,
received a copy.
that's why I asked if there's any, because we'll look and see, people can file motions the day of, but do you have copies for Mr.? That's his copies, okay, all right. The deputy's gonna come up and get it, thank you, thank you.
This is all his then?
Yes.
If there's any, just for future reference, if there's any evidence that he doesn't have, when you are ready to turn it in, I'll just take it from there, so he can see it and then I'll find it. And likewise, same thing, if you have anything that they don't have.
Oh, they already have a copy of everything except for the court transcripts and the video. And I'm not required to give them that.
It's essentially the motion on all of our behalf.
Okay. The first one I'm looking at is a motion to charge petitioner with menacing by stalking. Mr. Poss, are you an attorney?
No.
Okay, all right.
Yes, and that's a direct violation of ORC and
Hang
authorized practice
on.
login. That means you have to be.
Okay, I'm gonna ask you to not interrupt unless I ask you to, okay?
Okay, Your Honor.
All right, thank you. Okay, the way the law works is you can file a motion on your behalf, but you can't file a motion on behalf of other people, okay? Now, if they orally want to make the same motion, I understand that, but I'm just looking at the written motions being filed by you, okay? Because the first motion I'm looking at is to charge Mr. Warwick with what we call menacing by stalking. It's called motion to charge petitioner with menacing by stalking, but then you also ask for contempt finding to be issued against him.
Yeah.
Okay.
Yeah.
All right, and then you also have a motion for contempt filed. I've just handed these.
Oh, okay, I say, I didn't change contempt in the motion.
Okay, that's okay. Okay, so you're basically saying that
Right.
that
But
the
it's-
petitions
it
are
should be
harassing,
menacing by
okay.
stalking. I apologize.
all right,
I'm pressed for time to get here in time.
I understand, okay. I'll deal with those in a minute. Now, I do also have a motion to petition the court to change the term of the petitioner's probation.
The court does not have jurisdiction to do that, and on top of that, they also disproved my probation, Your Honor.
Okay. He is correct. I don't have any jurisdiction over his criminal case, okay? The motion to charge him with telecommunications harassment, I also,
All the motions are frivolous because you don't have criminal
hang
jurisdiction.
on, sir. I understand. I'm certainly not gonna make any rulings against you without giving you an opportunity to respond, right? Okay? So if you just let me talk, I'm addressing. So you're alleging that Mr. Rourke has engaged in telecommunications harassment? Okay.
Correct.
When I have this hearing today, that may be a viable defense to you if you think you're the one being harassed. You can certainly raise that and present evidence to that as sort of a response to his petition. So that will come in, but I don't have any authority to issue criminal charges against him. Okay, I just want to make that clear so that you can raise, if you think you're the one being harassed, that's a fair response to present today, okay? I'm looking at the first two motions I talked about. The motion to say that he's the one engaged in my menacing by stalking. Again, you are free to raise that as a response or defense. However, under the statute, I cannot issue orders against him today unless you filed your own petition and that you filed it more than 48 hours ahead.
I already have a civil protection order against him.
Okay,
It's
all
in
right.
the file.
So I understand, but this is gonna be your defense, is that you're the one being harassed, correct? Okay, all right. The last thing is, looking at your motion for contempt, I'm taking that as that you're coming to this court saying that this
Yeah.
is a frivolous action against you, okay? So we haven't made a ruling as to who's right or wrong, so that motion will be held in abeyance because I'm just a magistrate, so I can only rule on things that are referred to me. What's being referred to me is the hearing on his petitions and then Mr. James' petition against him. That motion will stay a part of the record. If Mr. Rourke does not prevail today, then the judge assigned to the case, could either have his or her own hearing or refer it back to me to determine whether, because somebody losing the case isn't the same thing as it being frivolous, but it is something that could be decided at a later date.
Understood.
So, but that still will remain part of the record then. Okay, thank you. Yes, sir.
Or since I found this email. Yes, Your Honor. I already sent an email to Jeffrey D. James, so I also have a motion to hear today about termination of all CPOs that are currently against me, Your Honor, that's been filed with the court and on these court numbers, as well as for the old ones that I do have currently against me, Your Honor.
When did you file that?
I'd have to look at my phone, but it was like more than 2 weeks ago.
Okay, well, again, I'm just a lowly magistrate, so
Oh, no,
I
I
believe
understand
that
that.
you filed those, but that's a totally separate. Were any of you served with motions to
Yeah.
terminate?
Jeff-
Okay, maybe they were, and we're not gonna argue about that issue since it's not telling pending for me, but that's again, same thing what I just explained to Mr. Poss, or is it Pass? Poss, okay, same thing explained to Mr. Poss, that is something that if you want to modify your CPOs or terminate them, so I'm behind the 8 ball because I actually don't know who any of you people are and what's going on, but, so you're telling me you have CPOs against you currently?
Yes, Your Honor.
You're moving to terminate those under those case numbers.
Well, yes, but I filed it on this court thing since they'll be testifying today, Your Honor.
Okay, but that's not, I wasn't given authority to consider whether those CPOs pending against you should be terminated, okay? That's not what we're here today, and so, if the judges want to refer that to me for another hearing, that's what will have to happen, okay? That's just how it works, I can only rule on what I've been given authority to rule on today. All right,
I think the other ones, you hadn't asked them if they had any preliminary.
I was going to, yes, Ms. Poss?
Yeah, he didn't check his name for my CPO. Like, he only filed for his mom and stepdad.
No, I didn't. I filed for myself.
You did not.
Hang on.
On my CPO.
Okay, let's not argue. So what are you trying to tell me that you don't think that it was,
On his CPO filing for me, he was asked who he's filing for. He did not mark the me box. He just marked the for others box.
sorry, my files are, I did not put them in numerical order, which I should have. You're Miss Poss, correct?
Yes.
Okay, well, your file's right on top. Do you have a copy of your petition you filed in front of you?
Not with me, Your Honor. I was saving that to file on the Flanagan's Dublin case against them, Your Honor.
Okay, because she is correct. For who needs protection, under box 3, you checked a family or household member who's not a minor child. You did not say that you needed protection.
Okay, well, I need one, but so does my mom and stepdad.
So that was a mistake on your part? You meant to,
No, I didn't mean to do that, but that's what the dude told me. He told me not to put down my mom and stepdad, so I don't know why they're doing that. My mom is going to be testifying today. Unless it wouldn't matter anyways, because if I have one against Steve, then I have one against Megan anyways, because that'd be third party.
Give me a second, I'm just looking over your petition again, because what you wrote in her petition is all respondents have caused mental, emotional, and physical harm by allowing the other respondents to libel, slander, and then the revised code section, unauthorized practice of law or tampering with evidence or falsification, and that this was all committed illegally against the petitioner. So, let me ask you this, Ms. Ploss, when you received this, what was your understanding as to what is being filed against you?
Oh, yeah, I didn't receive it. I had to come get a copy.
You sent it to a bar that we regularly go to.
No, they're in a business
Hang on.
contract with them, Your Honor.
Okay, because that's a totally different defense. If you're raising defense of insufficiency of service, are you telling me you've never were served with this?
I was never served.
And you just saw a copy?
I saw that something was filed online and I came down to the courthouse to get a copy.
How did you see something was filed online?
There's a week period of time in between, or there was a vague period of time in between when it was filed and when it disappeared for it being a civil protection order, so we knew that something was filed and we could see that it was civil protection was what was in the heading. So we kind of got the idea that that's what was being filed. We have to check the court sites regularly for filing.
Okay, so, and you interjected, Ms. James, correct? No, wait, you're Ms. Stark. Okay, you're Ms. James, okay. Same for you?
Yes, but I would also like to include in the evidence, I just discovered this, so I unfortunately don't have multiple copies. Kyle Roehrig filed for CPOs against Ms. Paz and I last year, and they were dismissed with prejudice.
Objection, Your Honor. They were involuntarily dismissed to Ohio Judicial Conduct. Rule 2.11, Magistrate Judge Pamela Erdy failed to state that she was disqualified from the case, so they were not dismissed with extreme prejudice. That's called a falsified court document and ORC falsification by a judge.
Okay, anything else? Okay, sir, do you have any preliminary matters? I'll address all this, but I just want to find out what all's out there.
Just what we got this evening.
Same, Ms. James?
Yes, it's the same situation. We were also not served and became aware of it because we regularly check the website for filings from this particular litigant.
Okay, so, Mr. Rourke, they raised 2 affirmative defenses, and then Ms. Poss also has the issue of the fact that you didn't check that you were seeking protection against her.
May I approach, Your Honor?
With what?
I have evidence of Megan James, which means she just lied to you. And it states, and I quote, every Friday night from 7 p.m. to close, we have the Columbus Line Dance Collective in the house, stomping the floor, teaching how to line dance. Come in and join us. Not only that, but Megan James and Jeff James are the DJ and line dancers there, so that's their work.
What, are you talking about the bar you served them?
I serve them at their work, yes, Your Honor.
Okay, so here, okay, nobody talk right now, okay? Thank you. Give me a second to gather my thoughts. Okay. The law allows certified mail to be served upon a respondent at an address that's reasonably calculated for them to receive it, okay? That's the standard I'm operating under. You're nodding your head, but I'm not making a ruling one way or the other, okay?
Okay, Your Honor.
My point to that is that is a valid affirmative defense because I'm hearing from some of you that under the law too, the fact that somebody knows about a lawsuit and came down to court and even looked it up, that's not proper service, okay? So I just want to dispel that real quickly, that the fact that they're all here, they clearly know about this case or they wouldn't be here, right? That's not service. Service needs to be sent to an address where it's reasonably calculated to reach them. I don't have enough evidence going just on arguments back and forth. Give me a second, sir, okay? As to whether or not service at that location, because you don't seem to be disagreeing that it was sent to a bar, correct? But you're implying that they're either there frequently or may even work there, so that's why
No,
you're
it's
saying
not.
it's reasonably calculated, so that may refute your position or it may not. at the end of the day, when you present your case, you're gonna have to, you can present those defenses. Procedurally though, Mr. Werg, we can do these cases. The other thing is Ms. Stark has raised an issue, the affirmative defense of res judicata, because she's claiming that something was dismissed with prejudice. You're disputing that. Again, that's something that I would need to have evidence on. People have to be under oath, properly present me documentation of that. Okay, we're not there. These are all defenses they can present when I get to them, or I'm kind of going to leave it up to you, because I don't want you to waste a bunch of time putting on your case. They're going to respond, and then they may have a valid defense. I may find they were never properly served, and that I'm going to rule against you, but that would be a dismissal without prejudice if it's for lack of service, and then we'd all just be here again, because I'm assuming you'd refile and try to get them served again, right? So we could either just go forward with the hearing knowing that if I find their defenses are proper, that may be the court's ruling, or we could first have a hearing today on their affirmative defenses, and if they prevail, then the cases are dismissed. If they don't prevail, then we would come back and hear the cases on the merits. I'm just letting everybody know that those are a couple different options. What's your response, please?
Well, I actually have a very simple method. Since they're already going to try to take the stand anyways, and you're stating that you're going to allow them to take the stand, why not just have Megan James and Jeff James take the stand and ask the question to them yourself, do you work for Flanagan's Dublin? As soon as they say, yes, we work for Flanagan's Dublin, they just lie to you, I get my CPO.
Well, no, it's not quite that simple, but are all of you raising the defense of insufficiency of service of process?
I travel a long distance. to
I
get
know.
here. Coming back again would be problematic.
Right.
Yeah, so, they're independent contractors for Dublin, it's not their employer.
That just proves they work there. Respondent superior.
They're independent contractors.
Yes,
Okay,
respondent
listen,
superior. Look it up.
it's not my job to educate people on the law, but you've got a couple problems here, because one, the first hurdle is whether it's reasonably calculated for them to get it, okay? They can still rebut it, even if you send it to an address that I find is, you know what, that was a good address, that I have no problem with it being sent to address. I could actually make that finding that they're there enough. They can still testify under oath and say, but guess what, I didn't get it. Meaning if you sent it to the bar and somebody signed for it at the bar and then didn't turn around and hand it to them, they haven't been served. The fact that somebody mentioned, hey, I think some court papers came from you, but if they testify under oath and I believe them that they never gave it to them, then they still haven't been served.
And I'm saying that's okay to do, Your Honor.
I hear you, okay. But that's my concern, is that it's not just whether, and that's my mistake, because I was focused on that first part about whether this was a good address to even be sending them service. But even if I find, yeah, it was a good address, if they credibly tell me that the person who signed for it, the bartender, the barkeep, whoever, the bar back didn't give it to them, then you still didn't get them served. So you see the problem?
Yes, Your Honor.
Okay.
We discovered it was being sent to, Flanagan's before it was delivered, and we contacted Flanagan's to ask them to go ahead and receive it on our behalf. The owner, is it the owner of
I don't
Flanagan's?
remember who it was, but they did say that they called the court and sent them back and made sure that that was the right thing to do.
Under the advisement of their attorney, they were advised not to accept service since none of us are employees or agents of Flanagan's.
And
They
independent,
can't accept it on our behalf, so they returned it.
Yes, sir.
as an independent contractor, they are actually allowed to accept it on their behalf because not only are they contracted there, but they know when they're going to be there and to work and to serve them when they're at work. Your
And
Honor.
maybe, I don't want to get too far into this, maybe the lawyer gave them bad advice and they should have just went ahead and accepted it, and that may favor you, but if they didn't turn around and put it in their hands, then you haven't served them. And that's just the way the law is. It's inefficient. What I'm hearing from everybody is because there is a little bit of an issue, but I need testimony to that. What I'd like to do is go forward on that issue, and if I'm on the fence, then I may just take it under advisement and just make everybody go forward on the merits anyways, still knowing that I may still grant okay? But if I'm comfortable today deciding you weren't served or that you were served, that I think you did, then I'll make that ruling, then we'll go ahead, okay? But let me,
Megan and Jeff are the only ones that are independent contractors of Flanagan's.
Okay, let's not-
Association.
Thank you. Okay, everybody, since everybody needs to present their own defense, though, that's how we're gonna proceed. I think everybody understands. We're gonna first, now, this is an affirmative defense. You folks on this side have the burden of proof. That's why you'll go first. I'm gonna let you raise your defense of insufficiency of service of process. And Ms. Stark, if you also wanna raise your defense that the case has been previously dismissed with prejudice, then you can put on that evidence at that time too.
I
And then-
unfortunately only have one copy. I just found it the other day, or else I would have made more copies.
I don't need a copy, Your Honor.
Okay, all right, well, we'll figure that out, okay, but let's, just so everybody understands, that's how we're gonna proceed, and then we'll just see where it takes us. Okay, give me 1 second. Okay, Mr. Poss, would you like to go first?
What am I going for, Sean? What am
On the firm defense that you haven't been served,
I, yeah,
and then I'm gonna,
I live in Florida.
hang on, why don't I just place everybody in your oath, even you, sir, that way I won't forget to do that for anybody. I'm gonna just place everybody in your oath. Thank you. Do each of you swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, as you shall answer to honor God under penalties of perjury?
I do.
Yes, Your Honor.
Thank you, everyone, okay.
I'm just gonna object for, or, note for the record an objection that they all just false swore, but I'm just gonna put that for the record, Your Honor.
Okay, thank you. Duly noted. Okay, Mr. Poss, right now, you're going forward on your defense that you have not been properly served. What would you like to tell me?
I live in Florida. I have nothing to do with Flanagan Dublin. I was a customer of theirs before, moving to Florida. But, I mean, I have a job where I work in Florida. I live in Florida. And it's a service being sent to, Flanagan's Dublin, and then getting rejected. The only, you know, like I said, we check the website frequently because he likes to file a lot of lawsuits. And so we kind of figured something was coming, so we were checking regularly, and then that's when we discovered, during that period of time when it goes to the website and before it disappears, that, they had been filed. So, contacted an attorney, asked them what to do about it and everything, gave me a phone number to call.
Objection,
I'm
Your
not even
Honor.
sure who I called at that time. But,
Okay, so what's your basic objection?
Oh, I waited for you to stop.
Yeah, I'm sorry, yeah.
No, you're good, that's why I paused. I'm objecting to saying that he contacted attorney. He needs to state what attorney he called, because I have evidence that an attorney is not just an attorney, they have another connection to Mr. Pass.
Okay, hold on. He can, you have the right to cross-examine him, okay? So if you need to know the name of the attorney, that's the time you can ask him that, okay?
Oh, no, Your
But-
Honor, I'm just noting
so-
my objection for the record.
Thank you. So overruled. So you contacted an attorney.
But yeah, let's say, I contacted an attorney and asked him for advice on what to do, it's just a friend of mine, and, he advised me to contact the sheriff's department, gave me a number to call, where they might be able to look it up to see where service went to. And the person was able to look it up and saw that service was going to Kane Road, which we knew to be Dublin, or Flanagan's Dublin. So, I got in touch with Jeff, since, you know, he, you know, does the independent contracting of line dances there on Friday night. Jeff contacted him, let him know, we believe something is coming, can you just go ahead and accept it? However, he contacted him later and said, I talked with my attorney, and because he has sued Flanagan's Dublin, the attorney advised us not to accept anything on your behalf, since you are not an employee or an agent of this organization. So his attorney advised him to refuse service, since that's not a good place to serve. Even, not just Jeff, but none of us, me and Megan and Ms. Starr, have anything to do with Flanagan's other than being a customer on occasions.
So, for sake of argument, let's say it went, are you saying it went to Finnegan's or Flanagan's?
Flanagan's Dublin.
Flanagan's, okay, so what
I
was
have a
the,
copy for the name if you need to see it to write it down.
okay, what's the name?
Flanagan's, well, I'm saying, I'm gonna be giving it to you, so I don't know if you just wanna go ahead and have it so you can type it down. Or if you want me to spell it for you.
Just spell it.
F for Foxtrot, L for Lima, A for Alpha, N for November, N for November, A for Alpha, G for Golf, A for Alpha, N for November, apostrophe, S for Sierra, D for Delta, U for Uniform, B for Bravo, L for Lima, I for India, and N for November.
Thank you. Appreciate it. Okay. I hear what you're telling me, that you actually wanted them to go ahead and sign for it, but then something happened and they said they couldn't do that. But if somebody signed for it there, did you ever get it?
No.
So nobody,
I picked up my copy yesterday morning when I got in, or yesterday afternoon when I first got in. I came down around 2 o'clock yesterday and got a copy.
you testified a minute ago that this wasn't your exact, I'm not trying to put words in your mouth, this is what, like, exactly what you said, but I think what you're trying to tell me is you had an inkling something could be coming. Can you elaborate on that?
He was released from custody on November 15th, and the charges were dismissed at that point in time.
Objection, Your Honor.
So,
No, I asked the question, okay, so now I'm just trying to figure out what he meant, okay?
yeah. can you-
So I'm not taking this for gospel, I'm just trying to figure out why he thought that there could be something filed,
Understand that
okay?
you are with perjury and direct criminal tort, I'm allowed to object to.
You, that's fine, but what's the basis of your objection?
He said I was released from custody on November 15th. I have a witness sitting outside that states I wasn't even in custody on November 15th.
Okay, well then you can cross-examine him as to that. Go ahead, sir. Okay, so your understanding was,
Charges were dropped on November 15th.
what charges? Like, how do you even know what was going on with him?
Violation of civil protection order.
What's your relationship with the young lady next to you? Got it, thank you. Okay. So, you found out that charges have been dropped and,
Yeah, we were notified by the prosecutor that they were going to go ahead and dismiss charges. And then almost immediately after charges were being dismissed, a campaign of various filings started happening in court. And I believe I was on the phone with Ms. Stark, and I said, so I guess, we can expect that, we can expect some sort of lawsuit coming towards us at any time. And then I thought, oh, crap, I better check. So I hopped online and I just saw a list of 5 cases. And I'm like, there it is. So I logged into each one of them, got case numbers, and then I could see under the heading that it was civil protection order, and just kind of figured it out from there. And that's, later I called down here to see if they could send me a copy. They told me that they couldn't verify my identity over the telephone. I would have to come down. I explained I live in Florida. So then I went back to the drawing board and I thought, okay, well, maybe I can contact the Franklin County Sheriff's Department and see if they can communicate with the Sheriff's Department where I live to go ahead and have me served in Florida. But the Sheriff's Department told me until the civil protection order is issued,
It's worth
they
it.
don't do service. So
just hang on.
I went, that's when I contacted, my aunt who works for an attorney's office and asked her, can you ask the attorney, for advice on what I should do about this? And that's when he gave me
Okay,
the phone
so-
number of somebody
All
that
right.
works out of the sheriff's office that could look it up to see where service was being
Okay,
sent, and that's when we discovered King Road.
And just so I understand what you're telling, Mr. Poss, because you've come, this first time you've come before me, I believe, based on the process we have with this kind of proceeding, you properly asserted the affirmative defense of insufficient service of process, but you have to prove that. But you still want to go for on the defense, because I'm hearing 2 things. I'm hearing that you made exhaustive efforts to actually get served, because it seems like maybe you want to get it over with, but at the same time, because if I find you haven't been properly served, then I'm dismissing it. Now, that puts the burden back on him to refile and try to hunt you down and everything, but is that what you still want to assert that defense? Because I want to just make it clear, because what you're telling me is that you
Well,
actually
it's-
did your best to get properly served. So what do you want to do? Are you
Right,
raising that
it's
defense?
part of the entire defense later that this is just.
I hear
The
you,
subject
but
matter
I
that
need
we
to
see
know
is
that before if I rule in your favor, I need you to just be I hope you understand what I'm telling you. Is this defense you want?
I would really prefer not to have to travel all the way back to Ohio.
I know, but if I have no control, right, but see, that's what I need to know. Are you raising this defense or not? Because, and you're not doing anything wrong, okay? But you need to make a decision, because I'm still gonna go forward and consider that, whether you've been properly served. If I find you haven't been served, then it's incumbent upon him to find a better address and get you properly served. It's different because you live out of state, so he does need to actually find you and get you served, but is that what you wanna do?
I'm fine with moving forward, and waiving service.
Okay, so you wanna waive service now, okay, thank you.
I'll waive service.
Is anybody else waiving service?
I would like to waive service, Your Honor.
Well, so you want to go forward and not raise this defense anymore?
Yeah, I wish to move forward on
Okay.
his filing against me, and ours against him as well, if possible.
Okay, thank you. Ms. Poss?
The issue comes is I would love to get this over with. However, he didn't mark himself to file a CPO against me.
Ms. Stark?
It was already, another CPO was already dismissed against me with prejudice, so he shouldn't be able to file against me again.
Okay,
Yeah,
you're
she
under
never
oath.
seen one I
What
saw.
is the case number of that case?
2-1, C as in Charlie, V as in Victor, H as in Helen, 5043.
What document do you have in front of you, miss?
This is the actual document, the dismissal of request for civil stalking protection order.
You want to submit that as evidence?
Yes.
Okay. Deputy Rose, can you grab that from her, please, and let him see it?
He wants to give to these guys?
Yeah, that goes to them.
Okay, fine.
So I'm not sure what it is.
Oh, no. And no, James already has a copy.
Can you let him see that first? Sorry.
Oh, I don't need to see. I already know what it says.
Okay.
Just real quick, Mr. James,
I wish.
are you waiving service? Okay, all right.
Any other business?
I mean, yeah.
Not right now.
I'll be asked. Any others?
It says the petitioner failed to appear for court. Petitioner left after case called into court. So that's two different things. So the petitioner the petitioner appeared but then left after the case was called. According the petition is dismissed with prejudice. It's signed by Magistrate Erdy and Judge Driza Page. Okay.
Wait. Hold up, Your Honor. That was signed by Judge Eze Page?
Well, there's a scroll here.
Well, yeah, I need a copy of that. I was not informed that she had anything to do with that.
Okay, see, this is why we let you look at it ahead of time. So maybe before you decline our offer, you look at it, okay?
Yes, Your Honor.
Thank you. All right. Do you want to look at it?
Actually, if I can just take a picture of it real quick, I'll give it right back to you.
I have
I can give it to you. I'll give you a copy. You're fine.
a
Okay.
question for service. She also has one of those because he filed for some protection order against her and on a consecutive case. He also filed consecutively a case against me for civil protection order in relation to that, but I never got served, so I never came.
You have the actual protection
So I
that he
don't,
filed. His actual filing over there.
Hang on, because
so I
these-
don't know if that's a blanket for me as well, I don't know.
so these defenses, they're affirmative defenses. Under the law, you have to prove it. So if you have case numbers that you can testify on your oath as to what the findings are, here's the deal. It was dismissed with prejudice. He can't go forward on anything that was raised in this, but I've got to hear from him too, give him a chance to argue. But anything that's new could still go forward, because this is a 2021 case. So I want to make that clear. Anything that he's talking about that happened after this date, he's allowed to go forward on, okay? So I don't know, are you going to present evidence of anything that happened after this date?
Oh, yeah.
Okay, so
In the
first
case
of
law,
all,
sorry.
what I need to know, though, in order for you to properly prove these defenses, I need to know what was being alleged in those petitions.
We have
Because,
He left, how long did he argue, what did he allege?
well, we have his actual filing. I have
Right.
hers for
so
some
that,
reason.
that needs to be admitted into the record.
I left it on top of the boxes. Did you put it there? Somehow I have hers.
Check.
Okay, it's okay, calm down, take your time, all right?
And we just requested copies of everything down at the clerk's office, so they've already pulled it, it's waiting down there for us, so.
Okay.
Your Honor, since they're gonna be a minute, can I step out to get a drink of water real quick?
Yes.